9 years. That's how long I've been dragged through vexatious litigation, case after case, despite the record showing the court lost jurisdiction August 4th, 2016. That is the record they have tried to erase as it makes everything downstream unconstitutional. Every attempt to obtain certified hearing transcripts, every request for preserved video evidence has been stonewalled or met with hostility. From court filings to preserve the records, to grammar requests to designate the records of historical significance, all roadblocked. Clerks and judges don't want certified records. One should ask why. Who is hiding the ball and why? Watch carefully. This isn't just paper. Behind these words are deeper crimes: obstruction, denial of access to the courts, retaliation for reporting misconduct. As you watch the security footage, ask yourself, what's really happening here? Is this the impartial system of justice promised by the Utah Constitution? Or is it the machinery of cover-up? What the cameras will soon reveal is something few expected: a court clerk admitting to wrongdoing on tape. At that moment, this stops being just state misconduct. That's when we enter the realm of federal crimes. When I walked into the courthouse on June 25, 2025, I wasn't there to cause a disturbance. I passed security without issue, said hello to the deputies I had seen many times over many years. They asked, "You're back again?" "Yes, I am reporting the crimes of a judge today." "Good luck with that," they smiled. I then waited in line and carried with me 2 filings, an affidavit and a petition for emergency judicial administrative intervention. The affidavit was my sworn testimony. 9 years of wrongful prosecutions, missing docket entries, backdated records, withheld certified hearing videos, unanswered grammar requests, and transcripts that never matched the truth. It told how a case supposedly settled years earlier kept being resurrected, dragging me into courtrooms without jurisdiction and fueled by federal VOCA funds. It was proof the system itself had gone off the rails. The petition was urgent. I wasn't asking for favors. I was asking for protection. I sought reassignment, record preservation, and an administrative intervention before more evidence disappeared. I asked for recognition of federal statutes, and I repeated my request for whistleblower protection, something I had asked for again and again over the past years. What happened next tells its own story. At the counter, Clerk Maria texted Judge Bullock's assistant. Bullock was in court, so the message was relayed to Trina Hansen. That hidden metadata, messages passed quietly behind the scenes, will one day reveal who falsely accused me of creating a disturbance. I was in the court public area for about 40 minutes. No disturbance was reported to deputies. Someone inside the system is retaliating. Could be the clerk. Could be Judge Lunnan, as I reported him to the JCC for his failures to honor his contractual obligations to dismiss my case with prejudice and to order the expungement stayed pending my motion. The trespass notice that followed was not supported by fact or law. I was at a public-facing counter, recording audio only, entirely legal in a one-party consent state under Utah Code Section 7723A4. No video, no interference with proceedings, just me documenting my own interaction exactly as the law allows. Yet within less than 24 hours, that false accusation transformed into a sweeping order hitting me between the belt, unconstitutionally and unlawfully trespassing me from every courthouse in the 4th District for a year. It was more than symbolic. My name was entered into law enforcement and judicial databases as a trespasser when no crime had been committed. That is retaliation. A citizen reporting judicial misconduct, punished not with justice but with exile. A trespass order built on sand, causing downstream harm that cannot be undone. And in that moment, the system itself crossed the line, from administrative overreach into federal crimes. What you've just seen isn't a simple misunderstanding. It's a chain of crimes committed behind the scenes: a false report, a false trespass order, spoiled court records, grammar violations, denials of a recording being a record, denials of court docket entries being depositive or records. On May 1, 2025, Judge Lunnan convened a hearing he had no jurisdiction to hold. I opposed the hearing because the case was closed. But instead of respecting due process, the judge muted me, refused to order preservation of the record, and then went even further. He denied ever making the oral contract that exists in the record, a contract already reviewed by Chief Judge Craig Powell. For 3 years, Judge Lunnan presided over a double jeopardy case, participating in proceedings that should never have existed. He signed orders, let prosecutions move forward, yet likely never read most of the filings. And when the truth began to surface, his response was not accountability. It was retaliation. Now, rather than address his own misconduct, Judge Lunnan appears to have authored a motion himself aimed at branding me a vexatious litigant. A judge creating and adjudicating his own motion in a closed case against the very whistleblower exposing misconduct. This is more than judicial error. This is an abuse of power designed to silence the one voice demanding preservation of the record, and with it, the truth. For the next 20 minutes, the cameras show me sitting quietly in the courthouse, reviewing my affidavit and petition. Documents meant to do one thing: preserve the record. Why would that matter so much? Because Judge Lunnan wanted those records to disappear. The record shows that for 3 years he presided over a double jeopardy case, failed to report it, and allowed federal funds to be misused to keep the prosecution alive. That's the truth hidden in my filings, not my disturbance, not my misconduct. The misconduct was on the bench, and these filings made sure it could not be erased.
Hi. So I need to get this to, let's see, yeah, that's the copy for you. I've got a case that has been dismissed, and I'm trying to preserve the record. And Judge Lunan has said that he is no longer has jurisdiction. He doesn't have judicial jurisdiction, but he has administrative obligations. He doesn't want to preserve records because he admitted to diligence and competency violations. It's a double jeopardy case, so they've torched the records. The states erased all of the case records, and I've still got a motion that I'm the only one that has standing. And I said, let's preserve the record. So I need Craig Powell, whoever's the boss, to make an emergency ruling. The Judicial Conduct Commission's opened up a case against the judge, and there's evidence of that inside of here, as well as post-dismissal. The prosecutor called the hearing, doesn't have standing. He's asked for a copy of audio, didn't have standing.
So you already had these stamped, I'm assuming, by Mindy?
Yeah.
Okay, I just
But
want
they
to make sure that's an official here, that
Yeah.
this isn't something you put on.
Yeah.
Okay.
I submitted a filing electronically, which the clerks have not put into the record. In the post.
When did you do that?
A week ago. So in the post dismissal hearing, The judge, when I was speaking, preserve my record, shut his microphone off. He shut my microphone off 3 times while I was asking to preserve records and issue subpoenas. Shut his mic off, shut his mic off. So, it's all documented.
My understanding, Mr. Allen, is you've been directed to go through Bryson King at the AOC. Is that correct?
I'm working with him as well, but
Okay.
because the state
My
is,
understanding is you're supposed to go through him for everything.
well, no, he's just doing a back-end audit.
That's not what he's told me.
Well,
He's told me to refer you to him.
well, those need to go to a judge because,
They'll go to a judge. Yeah, they'll go to Judge Powell.
okay, all right. So I am working with him. I've given him a list of things to do, but the state just requested post-hearing. They got an audio, and I don't know why they're still meddling in the issue that's supposed to have been dismissed.
Because it sounds like everybody's meddling in the issue that was dismissed.
Well,
To me,
they just
as long
won't
as
preserve the
everybody keeps
record.
meddling is, well,
They just won't preserve the record.
I don't know what you mean by preserve the record.
The Zooms have been erased. The WebExes I've asked for, subpoenas I've asked for
I don't-
a long time
Well,
ago.
We don't have authority to
We,
erase anything.
we don't erase anything.
Okay, well, that's what, Dan Burton at the state, I did a grandma with him. He says, everything's been erased. We expunged it.
That's the AG's office.
Yeah, and I said, the
Well, but
cases,
you have cases that are expunged, right?
I do, but this case here is not expunged.
Yes.
And that's what
And
he's,
you've been able to get the audio on these.
I've been able to get it from you guys, but the state prosecutor that came at me said, we don't have any records, we've deleted everything.
They won't have record.
But they won't. The court is the one that keeps the record.
But the prosecutor should have records of 3 years of prosecuting me.
That's
The,
on that.
the case was resolved, they probably destroyed.
They don't destroy,
That's not a court problem. That's a problem with them, not the court.
I know it is.
So, yeah,
And
we
they're-
can't tell them to do
I
something.
know, they're trying to blame you guys.
No, everything that's been done on your cases is on the record.
I know, and they're saying the court ordered us to expunge things, so we destroyed everything.
Well, if the judge signed an order granting an expungement,
He didn't.
he did in 2 cases. Judge Brady did.
I know, but in this case, he didn't
Not this
because
case, yeah.
it's on my motion. And I said, no, we're going to keep it open because it's a double jeopardy violation. And so the state is saying, we don't have any records. And they're trying to blame the
But that's nothing
judge.
that this court can do.
Oh, I know, but that's what this is about, is preservation of all the records and notification that the state is trying to lay blame on the court because of their actions to
That
destroy
sounds
stuff.
like more of something that you would file as some sort of,
Probably with the state bar.
with the state bar, or in the office for them.
I'm
not
doing
the
I'm doing
court.
that as well. But with the judge retiring in a month, I don't want anything related to this case to be destroyed.
It won't be by the court.
So that's what this is to alert, because
But the
Judge,
court can't order other agencies not to destroy things.
I'm not asking them to do that, but I'm just putting Judge Lunen's boss on notice as to what is going on, because Judge Lunen says, I don't have authority. He has administrative obligations to preserve the record, and he's trying to.
Yes. That's what the clerks do, is preserve the record.
But he's saying on the last page of this, on the last 2 pages of that affidavit, he's saying, I'm out. Mr. Allen's filing stuff to preserve. I'm out. I can't make any decisions.
He can't.
Administratively, he has to preserve the record.
I think we have a miscommunication on what preserving the record means, so.
What
But I will get these two.
what does it
to
mean?
tell.
What does it mean?
So preserving the record of what had the things that happen here at the court, recordings, minute entries, those are preserving the record as far as the court is concerned. Now, how the county attorney's office, the county attorney, defense attorneys, the AG's office, we don't have any say on how they preserve their records. So we can't tell them how to do their thing, and they do whatever it is they're tracking, how long they keep their things. The court is always there.
Okay.
So-
So are the videos? Because I'm requesting the videos. Can I get copies of the videos
Can you get copies of the videos? What kind of videos?
of the WebEx hearings?
Of the WebEx hearings?
Yeah.
That's probably a grandma request.
Well, okay, I did a grammar, I got the audio, but I'd like the video.
Okay, that has to come through my boss, upper, for you to be able to get the video.
Okay, and can I do a motion or a petition?
You would do a grammar request.
Okay, and
Is that correct? Because it's not.
and who do I direct that to?
You would direct that to Mark Curie.
Oh, Mark? Okay, all right.
Yep. He's
Okay.
the one. And if it's a legit grammar request, because we've been taking him your other ones, and he's kicked them back because he says they're just copy requests. So, but because all of it, everything you're asking for is in the record that you're asking for. Now, if it's something that's not in the record, such as, well, sometimes we have police officers come in here and they want a video of somebody that came into court and is going up on, takes the elevator and goes up on a floor. That's a grammar request.
Okay,
Because we don't keep those things because it's just somebody coming and going.
Yeah.
But they might have committed a crime when they stepped out of the elevator to smash somebody over the head. So the police want that. Those are the kind of things that are grammar requests, things that don't normally go into the record.
okay, but the court WebEx, so I do have a grammar request in for correction of a record. So there was an omission back in 2016 in the certified clerk certificate. They left out one entry that said the case was trial canceled, case settled. So Tracy was working to get that corrected, and that grammar has not been responded to in a timely manner.
Is that in the Judge Brady case?
Yeah,
Okay, yeah, I can't talk to you about that. That's a Tracy deal.
Okay.
I'm only with Judge Lennon.
okay, all right.
So, yep, and if it's a note and it's made in blue, that's a note. There is no document attached to it. And when we cancel a hearing, it puts that little blue note and says this hearing has been canceled. There's no document attached to it.
Yeah, but that's what I've been prosecuted for a settlement agreement that never existed.
But that has nothing to do with a blue note that says it's been canceled.
Well, should it not show up in the certified judgment certificate as well?
No, because it's a note. When we use our software, it's called Chorus, when we use that software and say somebody calls us and says, attorneys, and they say, hey, we need to continue this hearing, we're not ready, we haven't got all the discovery, we need to continue the hearing, can we get 2 more weeks? And they'll do that a lot, and the state come back and says that we agree to the continuance off the record. Then when we change the date, it puts that little note in there, says this has been canceled, and then it'll show a new schedule date.
Okay, but there was,
And there's no paper attached to it.
okay, there was an audio recording of a settlement agreement that got erased by your IT department automatically.
Now, is this a Judge Brady?
Yeah.
Okay.
So I'm just asking
Yeah.
I'm just asking technically, how does that work when somebody leaves a voice message? Who would they have left that with? That would it have been left with the clerk? Because it was that recording that has caused me a lot of problems because it got erased. Nobody ever memorialized a settlement.
So IT called somebody and left a message?
No, my attorney called and left a message with the other attorney, and that got erased, and that was the basis of a settlement agreement.
Well, that wouldn't come through the court's phone system. That's from attorney to attorney, from their phone to the other phone.
Well, it was attorney to attorney, and
Yeah, and it's not through here.
well, they did a 3-way call.
And did somebody answer, or they left?
No, they left a message.
And that's not a record.
Yeah, that's not a record.
Well, and that's what I got prosecuted for.
Okay,
That's an attorney's.
that's an attorney issue.
I know.
So that you need to focus your attention on the attorney that was.
Well, it's part of the whole thing because there's 5 cases that resulted from that one thing. So I've been prosecuted for the sins of the prosecutors and the attorneys.
Okay. I will give these to Judge Powell. I'll have his clerk enter them and
Okay.
we'll get them to Judge Powell.
All right, thank you.
Okay,
And
you're
you are you Trina?
I am.
Okay, thank you.
You're welcome.
This has cost me $700,000. It's made me homeless. I've lost my daughter. And the Utah bar is trying to blame you. And the attorneys, he hid evidence for 3 years. My attorney had 9 active investigations when this was going on. So there's about 15 There were 15 active investigations. Then I turned David Levitt in. And he dismissed my case, but then my accuser put heat on him, filed a federal complaint against him, and weaponized against him. So then they retaliated with this one because I told the truth.
I'm not familiar with the past, I know.
So that's this is.
I mean, we
this
see
is-
thousands of cases.
I know this
here,
is the capstone of the misconduct that I'm reporting, and so the JCC, the OPC, my senators and legislators, I'm just saying, hey, I shouldn't have to police the bad prosecutors, and a bad prosecutor that lies in front of a judge should not be in the system, and somebody that withholds Brady evidence for 3 years shouldn't be in the system. I mean, they deceived the appellate court judges. They withheld evidence. It was through Grandma appeal that I found the recording, and I had not agreed to those terms. So I've been prosecuted for everybody's sins but mine. So anyway, that's the backstory.
Okay.
That's
I
why.
don't get-
That's why
yeah.
you've had a flurry of papers.
Yes, so
Anyway,
I understand that.
all right. Thank you.
All right.
I'll get that off the mark then.
Okay, yes,
right.
that's where you'll need to find
All
it.
right. All right. Thank you.
And they do know here if you turn it in here.
Can I just do it electronically? I
You
just
can,
do it.
just send it into the Provo filing.
Okay.
And they will get it where it needs to go.
All right. Thanks,
Okay,
Trina.
you're welcome.
Court Clerk Trina Hansen's statement further implicates the 4th District Court in record spoilage. In addition to the prosecutorial misconduct exposed through Grandma appeals, a critical revelation emerged from within the 4th District Court itself. Court Clerk Trina Hansen, when confronted about the missing August 4, 2016, audio recording left on the courthouse voicemail system by attorneys Albert Prano and Wesley Hutchins, claimed the recording was not a record. That assertion stands in direct conflict with Utah's Grandma statute, which explicitly defines record to include audio recordings made or received by a governmental entity in connection with the transaction of public business. Utah Code Section 63G2 103-22. Hansen's statement does not merely reflect ignorance of the law. It confirms that the 4th District Court actively participated in record spoilage. The deleted voicemail was not trivial. It was the only contemporaneous recording of a last-minute, off-the-record settlement that Prano and Hutchins used to cancel a hearing and assert that the case had been resolved. This voicemail became the procedural and evidentiary linchpin for every downstream prosecution against Mark Allen. By claiming that the voicemail wasn't a record, Hansen provided cover for its destruction, effectively eliminating a piece of Brady material that could have exonerated Allen and exposed prosecutorial misconduct at its inception. The consequences of this denial are systemic. The destruction of that recording violated Grandma. It removed from the record exculpatory evidence that both prosecutors and the court had a duty to preserve. It allowed false representations to stand unchallenged in subsequent court proceedings. This now places not only the county attorney's office, but also the 4th District Court under direct scrutiny for constitutional violations, including obstruction of justice and denial of due process. 6 years later, the evidence is no longer circumstantial, it is institutional. The 4th District Court, through the actions and statements of Clerk Trina Hansen, has been implicated in the concealment, deletion, and denial of a critical judicial record. This, combined with prosecutorial suppression, confirms a coordinated failure of the judicial process and triggers potential liability under both state law and federal statutes, including 42 U.S.C. Part 1983 and 1985, and 18 U.S.C. Part 915-19, destruction or falsification of records in federal. And now, June 26, 2025, this letter, a trespass order banning me from courthouses across 5 counties. Why? Because I dared to document my own presence inside the court's public space. Because I asked for accountability. Administrative Office of the Courts. This letter serves as official notification being served to you of a trespass order for all Utah District and Juvenile State Courts within the 4th Judicial District of Utah. This includes Wasatch County District and Juvenile Courthouse, 1361 South Highway 40, Heber City, Utah, 84032, Utah County. Provo District and Juvenile Courthouse, 137 North Freedom Boulevard, Provo, Utah, 84601. Spanish Fork District and Juvenile Courthouse, 775 West Center.
This is a violation of Utah Rules of Judicial Administration 4-401.02. In addition, your behavior was disruptive to staff, patrons, and court operations. Therefore, you are now trespassed from all Utah District and Juvenile State Courts within the 4th Judicial District Court of Utah for a period of 1 year. The order is as follows. Mark Stewart Allen, date of birth January 29, 1962, is hereby trespassed from all the 4th Judicial District and Juvenile District Courts of Utah for the duration of 1 year, beginning June 26, 2025, and continuing until June 26, 2026, except for the following reasons. Mr. Allen may enter any 4th Judicial District or Juvenile District Court of Utah within 15 minutes of a calendared, scheduled hearing, which requires his presence, and must proceed directly to the courtroom of the hearing. Mr. Allen may utilize the public video court terminals for scheduled virtual hearings, of which he is required for attendance. Mr. Allen may not patronize any judicial clerical spaces or customer service counters, and must depart immediately at the conclusion of the hearing. All filings or communications with any member of the Utah State Courts shall only be conducted in accordance with Utah Courts rules for filing and submitted via third-party delivery service or filed by a Utah Bar licensed representative. Furthermore, clerks have been notified that they may refuse any direct calls for the duration of this order. You may contact Bryson King, legal counsel for the Utah State Courts, with questions or for assistance with your case. If you enter upon any of the courthouses indicated in this letter without a calendared hearing, or fail to act in a peaceful manner, you will be referred to law enforcement for charges of criminal trespass pursuant to Utah Code 76-6-206. If you have questions, please feel free to contact me. 801-57-83835, chris.p, at utcourts.gov/s/Chris Palmer. Chris Palmer, Court Security Director, Administrative Office of the Courts, CC. Bryson King, Associate General Counsel, Administrative Office of the Courts. Mark Urey, 4th District Court Trial Court Executive. Shelley Waite, 4th Juvenile District Court Executive, Utah County Sheriff. Wasatch County Sheriff. Juab County Sheriff. Millard County Sheriff. The mission of the Utah judiciary is to provide the people an open, fair, efficient, and independent system for the advancement of justice under the law.